Calling upon our first speaker, who shall introduce us to the aforesaid subject, CA YASHU GOEL. CA YASHU GOEL is a fellow member of the Institute of Chartered Accountants of India and has been practicing in the field of direct and indirect taxes. He pursued his BCom honors from Delhi University and currently writes columns for several weekly newspapers having circulation all over Delhi. He is also the Joint Secretary cum Treasurer of the Sales Tax Bar Association, Delhi, and has been advising the DVAT authorities towards implementation and improvement of the DVAT software. Recently, CA YASHU GOEL presented the budget analysis for Union Budget 2013 on TV News channel. We are pleased to have him as our speaker today, and may I now request him to come and address us on the issue. CA YASHU GOEL.
Guests, members, fellow colleagues, good evening. Sorry for the fumble. Today we shall discuss the topics: subsequent sale under CST Act and the liability of contractor vis-a-vis turnover of the subcontractor under VAT laws. To understand the subject in hand, I will start with the concept of a simple central sale under the CST Act. Section 3A talks about a sale or a purchase which occasions the movement of goods from one state to another. And 3B talks about a sale or purchase effected by transfer of documents of title to the goods while such goods are still in transit from one state to another. Now, Central Sales Tax Act envisages single point taxation. Under such scheme, a subsequent sale made during the movement of goods from one state to another to a registered dealer is exempted from tax and is called a transit sale or a subsequent sale. Now friends, for the next 5 minutes, please enjoy this presentation with me. Now, in a transit sale, there are 3 parties involved. The original seller, who is in Himachal, the middle buyer, who is in Delhi, and the ultimate buyer who takes delivery of the goods. He is in Uttar Pradesh. Now let us meet our 3 friends who are going to help us understand the concept of subsequent sales and the issues involved. The dealer in Himachal is Harish. The dealer in Delhi is Dadu. And the dealer in Uttar Pradesh is Umesh. Dadu in Delhi made interstate purchase from Himachal and then made subsequent sale to Umesh in Uttar Pradesh. Now, to complete a transit sale, there are certain conditions that need to be fulfilled. Now, please be very careful, as I'm going to be very fast in my presentation. The first condition is that the original sale made from Himachal has to be a sale under Section 3A or 3B. The second condition is the subsequent sale made from Delhi to UP has to be a sale under Section 3B. Third condition is that Umesh in UP, who shall take the delivery of goods at the end, has got to be a registered dealer. Then, now this is very important, subsequent sale has to be made by Dadu of Delhi while the goods are still in transit from Himachal to Delhi, and then Dadu must make this subsequent sale without taking delivery of the goods by way of transfer of documents of title to Umesh. Now, the goods were sold while they were in transit from Himachal to Delhi without taking delivery by way of transfer of documents of title. And last but not the least, the goods being sold must be mentioned on the RC of Dadu in Delhi and Umesh in UP. Now, let us understand the flow of statutory forms at various stages. This is very interesting, sir. Please see. Virtually, there are 2 sets of transactions present. First one is the central purchase made by Dadu, the central purchase made by Dadu from Himachal, and the second is the subsequent sale made by Dadu to UP. Now, at first, Dadu will give a C form to Harish in Himachal. This is to prove that the central purchase was made from a registered dealer and by a registered dealer. This way, one part of the transaction is taken care of. The central purchase part is taken care of. C form is given, matter over. Now this comes the second part. Now for a subsequent sale, Dadu shall have to prove two things. First, that the goods were sold while they were still in transit. And for doing so, he shall have to obtain an E1 or E2 form as may be applicable from Himachal. Once he has obtained the E1 form, it proves that the goods were sold while they were still in transit. Then, he also has to prove that the ultimate sale, the ultimate purchaser was a registered dealer. For this, he shall have to obtain a C form from Uttar Pradesh. Now, Dadu has got two forms. One is the E1 form and the other is the C form. He collects both these forms and presents these forms to his assessing authority, and the matter is over. Now, let's discuss some situations. What happens if he has got the C form, but he has not procured the E1 form? Then what happens? He has got the C form, but he has not procured the E1 form from Himachal. Now it will be treated as if he has made a simple central sale and not a subsequent sale. It will not be exempt and it will be taxed at the rate of 2% because it is a sale against C form. Now, very important. Let us say that Dadu has obtained the E1 form but fails to obtain the C form. Now what happens? Sir, if the C form is not obtained, the entire exemption shall go and full tax shall be charged. Say the item is taxable at the rate of 20%. Full 20% tax rate will be charged in this case. Now, there are certain situations under second proviso to section 6.2, which provide that a C form is not required. A subsequent sale takes place. Even then, transaction remains exempt and a C form is not required. Now, what are these conditions? Let us see. The first condition is that either the goods which are being sold should either be exempt or should be taxable at a rate of less than 3%. And it remains the duty of Dadu, the dealer in Delhi, to prove to his assessing authority that all other conditions stipulated under section 6.2 have been complied with. Now, let us move on and discuss some other issues. These issues which caused conflict and were put to rest by the court of law, they deserve mention here. Now let us see and change our example a bit. Please pay attention to the slide. Now let's say that this dealer, who is the ultimate buyer, is not a dealer in Uttar Pradesh. In fact, he is a dealer in Delhi. Now see what has happened. Interstate purchases were made and the subsequent sale is being made within the same state, within Delhi. Now what happens? Sir, this issue was put to rest by Madras High Court 36 STC 370 East India Corporation, which said, the subsequent sale transaction conducted within the same state shall be considered as if it was a central sale and the sale transaction shall remain exempt. See how beautifully it comes up. The transaction shall remain exempt. Now, let us move on and discuss another issue. Very interesting, sir. Very interesting. The goods which are moving from Himachal are exempt. The government did not get any tax. Goods moving from Himachal are exempt. Now, if I make a subsequent sale, what happens? Shall it remain exempt? Yes, this question was answered by Delhi High Court, 34 VST 417 in Mitsubishi Corporation. And it was held that the transaction shall be treated under section 6.2 and shall remain exempt. Friends, there are many other issues that need discussion, but ends of justice can be met only then they are dealt in the able hands of our learned keynote speaker. Now, let us move on to our other topic of the day, that is liability of contractor versus turnover of the subcontractor. Let us start with another example. Here we have a contractee, a main contractor, and the subcontractor. The contractee awarded a contract to the main contractor for rupees 100 crores. 100 crore रुपए का contract contractee ने contractor को दे दिया. Now the contractor is a very smart man. he gave the execution of this entire contract to a subcontractor for rupees 95 crores, thereby making a profit of rupees 5 crores. Now, we understand that there is no privity of contract between contractee and the subcontractor, right? There is no privity of contract between the contractee and the subcontractor. Now the issue arose that what shall be the amount of turnover declared by the main contractor in his VAT return? Shall it be rupees 100 crores? That is the amount of the entire contract. Or shall it be rupees 5 crores? Sir, the issue became a conflict and the matter went up to the Honorable Supreme Court of India. The apex court held in the case of State of Andhra Pradesh versus Larsen and Toubro that even in absence of a privity of contract, it cannot be denied. Please be very careful. It cannot be denied that property in goods moved directly from the subcontractor to the contractee, and there is a deemed sale. And to avoid a possible double taxation of turnover, the main contractor should be allowed to do what? Please pay attention. To deduct the turnover of the subcontractor in his VAT return. Now, what happens? This is a judgment given by the Supreme Court. Now what happens? The Honorable Delhi High Court took a contrary view in another judgment of L&T itself, where the facts were similar to the above mentioned case, and held that the decision of the Supreme Court in the L&T case would not be applicable in the present case, as it was in the specific context of Andhra Pradesh VAT provisions. It was held that there is no multiple tax under the DVAT Act, despite there being no such specific provision for deduction of the amount paid to the subcontractor, based on the fact that the DVAT Act provides for an input tax credit mechanism, thereby reducing the output tax impact on the contractor to such an extent of the input allowed. Now what has happened? After pronouncement of this judgment, the issue remains a conflict. And for a much deeper analysis of the subject, I hand over the proceedings to our keynote speaker, Shri Venkatramanji. I thank you all for giving me a very patient hearing. Thank you so much.
Yashu ji, thank you for providing us with the knowledge and the informative